The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everyone. We're going to let people start signing on, and we will be starting the event shortly. Good afternoon. We have a large group coming on today, so we'll be starting the event shortly. We're just waiting for everyone to get logged in. Good afternoon, everyone. We're waiting for more people to log in. We'll be starting the session in about 1 minute. Good afternoon, and welcome to AICC's HR COVID-19 Advice and Input webinar. I am Taryn Pyle, and I will be hosting this call today. If you are new to AICC webinars, I want to welcome you. We have a few housekeeping details before we get started. Today's call will be 60 minutes long. After the presentation, Christine will be available for additional questions after the 60 minutes, so if you can stay, please do so. We will be providing a recording via the email that you registered with, and any materials discussed or offered will be placed on Dropbox, and you will need to download them to your computer. I will tell you there is a lot of information in the handout. We have loaded up the handout as a PDF on the handouts file here in the webinar area, so you can download it here, but you also will be getting it with the email. I do want you to know that on these calls you can hear us, but we can't hear you. We do this because we're recording this webinar. You can post comments and questions in the chat area located on your control panel. So what I'd like to do right now is a sound check and test to make sure you can hear me and the presenter. Please raise your hand or type in the question or chat box how many people you have on the call today. Okay, great. I got that you can hear us. Questions posted will be answered at the end of the call so that we have them recorded, and Christine will also be available on our weekly call tomorrow to answer additional HR-related questions. With technology, there is always a possibility of losing a connection, sound, or viewing of the presentation. AICC will keep you posted on the status of any problems using the chat feature. If you get a dial tone or are disconnected from the site, you will need to call back in. This would indicate a connection problem on your end. As we begin, please remember AICC is an international trade association, and as such, members are bound to uphold the letter and spirit of all applicable competition and antitrust laws, including those of the U.S. and Canada. During this meeting, there will be no discussion allowed concerning prices, customers, customer or market allocations, specific accounts, discounts, terms, and all other matters prohibited by law. We will have to end the webinar immediately if there is any violation of the antitrust laws. And now I want to introduce you to Christine. Christine Walters has more than 25 years combined experience in management, HR administration, employment, law practice, and teaching. She has received national and regional awards presented at conferences across the country, been engaged as an expert witness for the defense, and testified before U.S. congressional and state legislative committees and administrative agencies on employment issues. Her book, From Hello to Goodbye, Proactive Tips for Maintaining Positive Employee Relations, has been one of the publishers' SHRM Great 8 bestsellers for 7 consecutive years and is pre-approved by HRCI for 2.5 continuing education credits. Today, Christine works as an independent consultant, providing proactive human resources and employment law consulting services and training programs, doing business as 5L Company, helping leaders limit their ability by learning the law. Christine is licensed to practice law in the state of Maryland. And so today, Christine, I'd like to welcome you.
Taryn, thanks so much. Thanks to AICC for asking me to join you all in the conference. And with that, I say let's just go ahead and jump right in here. So What do we have on the agenda? We're going to spend a lot of it on just legal issues, things to think through as we all struggle to try and administer all the new programs under this law and the issues that are coming up. I did, and again, I thank AICC for the invitation. I did dial in to your call last Friday, so I picked up a couple of the questions, HR and employment related questions. So I'm going to try to touch on those at the end. Some other common questions, what's on the horizon, and some resources. Very, very important. This program does not constitute the rendering of legal advice by AICC or me, despite the title, which has advice in it. I think a lot of it is you all sharing your practices with one another, proactive practices. Please do consult with your company's employment or other legal counsel for advice on any specific issues. So let's begin. We're going to do alphabet soup. I tried to put these orders to organize them. I just put them in alphabetical order. So here we go. Let's start with, what are any potential issues under the Americans with Disabilities Act when we're dealing with an employee who's tested positive, might be positive for COVID-19, et cetera. On March the 19th, the EEOC published some updated guidance about what questions can we ask? Can we test employees? What do we do with applicants? They published another updated guidance on March the 21st. When you download the PDF file, everything that's highlighted, you'll be able to just click on those links and they'll take you right to those resources. We want to make this as easy as we could for you. Also, tomorrow, at 2 o'clock, which I believe also happens to be the same time as AICC's weekly call, the EEOC is going to make public a pre-recorded webcast. If you can't make it at 2 o'clock, that's fine. That's just when it's going to roll out. So we'll all be able to access it thereafter. So in a nutshell, it's under the Americans with Disabilities Act. We just want to avoid treating someone differently because we think they might have a disability under the ADA. We perceive them, that is, to have one. They actually have one, or they associate with somebody with a disability. So I'm going to give you some real quick examples from the EEOC's, some of these recently updated guidances. Yes, you can ask an employee if they are currently experiencing COVID-19 symptoms. You may want to consider using the CDC's definition of COVID symptoms, which is fever, cough, shortness of breath. Can we send them home if an employee is exhibiting those symptoms or says they are? CDC guidance, EEOC guidance says yes, you can. Can we take employees' temperatures? This was, I have to say, when this first started, I don't know how many weeks ago, here's the trend I've seen. The first questions were all about health and safety. Who can we borrow from our workplace? Who should we bring in? All that. Now the dialogue's very much, I think, shifted to the fiscal issues. I think the third phase may be, how do we keep our employees who are teleworking or furloughed, how do we keep them engaged so they'll come back to us? And then I anticipate phase 4 may be, when we're bringing folks back, I think there's going to be a lot of questions. But anyway, in the beginning, can we take employees' temperature? EEOC updated guidance says, yes, you may. Keep in mind, just because I have a temperature, just because I have a fever does not mean that I'm COVID-19 positive. So, just think about, what are you going to do with that information? It doesn't necessarily mean that they have it. The other question is, how do we take their temperature? Thermal scan, thermometer recommended, generally speaking, rather than an oral thermometer. Oral thermometer, you're also going to have the issue of make sure you're cleaning it in between each one. So I think anybody who's doing it, I'm hearing most are using the thermal scan. So again, just be cautious. For example, an employee who has allergies, they're going to sound stuffed up. An employee who has chronic asthma, they're going to be coughing and wheezing, but that's something that they've had unrelated to COVID-19. Next up, Age Discrimination in Employment Act. Just avoid treating older workers. So the ADEA prohibits discrimination against employees who are, employees or applicants perhaps, who are age 40 and above. And so just make sure any decisions you make, just ask yourself, are they based on age? For example, a couple of questions I've gotten are, Christine, I have an employee, the employee is age 74. I'm worried about that person. I don't want them to contract, the virus in the workplace and then I'm liable. I think they're at higher risk. And a distinguishing remark that I'm hearing from the CDC, NIH, other groups is the older population, of which some of us might be members, I'm not reading that we're at higher risk of contracting COVID-19. We are at a higher risk if and when we contract it, of having more severe complications. So again, if you're having any, if you hear yourself thinking about, I wonder if I should do something for an employee because of his or her age, pause and just, think that through a little bit. So now we're going to a couple of issues, and there's a lot of them, but a couple of issues under the Fair Labor Standards Act. A lot of questions we're trying to figure out. So here's our first scenario. Lots of employers are facing reductions. I have to reduce employees' hours, not reducing their pay, like I'm going to reduce your hourly rate, but you're going to take home less pay if you're working less hours or fewer hours. Keep in mind there are a number of states that require advance notice before an employer reduces an employee's pay or pay rate. Now, I could argue, I didn't reduce your pay rate. I reduced your hours, which subsequently did reduce your pay, but I didn't reduce your pay rate. So, rather than risking getting into a quibble about this, just double check your state, see if your state has a related law, and then a lot of them, the majority that I've seen, are at least one period's notice in advance. Let's face it, I'll use Maryland as an example. I think at 11 o'clock the other day, maybe Monday, our governor had a press conference and said in 6 hours, non-essential businesses have to close. So you have to work with what we have. I hope federal, state, and local agencies will be flexible in enforcing existing laws and understanding we can't give advance notice if we don't have advance notice. But where you can give that advance notice, do so if you can or consider doing so. What about hours? Again, same kind of reduction. If you reduce an exempt employee's hours, that also reduces, right? It's going to reduce the employee's minimum salary. So, again, let's just make sure we understand. Exempt employees under Fair Labor Standards Act, they don't get overtime. They get a guaranteed minimum salary regardless of hours worked. So if I'm a full-time employee, you're going to reduce my hours maybe to 3 days a week or 4 days a week. So I'm on partial furlough. I'm going to keep working, but at a reduced schedule of hours to be worked. You might prorate my salary. If I'm going to work 4 days instead of 5, you're going to give me 80% of my guaranteed salary, and so on. Make sure, or just double check and see that reduced guaranteed minimum salary will still be at least $684 a week, because that's under the Fair Labor Standards Act. That's the minimum guaranteed weekly salary that an exempt employee must receive to still be properly qualified as exempt. Now, and then next step is, double check your state. There are a number of states that have a guaranteed minimum salary rule for exempt employees that's higher than the federal rule. So make sure you're double checking both of those. And remember, exempt employees, generally speaking, and I'm going to qualify this word must, generally speaking, they must be paid their full day salary, even if they only work a partial day. Now, is there an exception to every rule? Well, yes, there is. And so even before COVID-19 came up, there's been an exception to this rule, and it has been intermittent family medical leave. So those of you that today, before April 1st, are FMLA covered employers, that is, you've employed 50 or more employees for 20 or more weeks in this or the preceding calendar year, you've always had this exception. If an employee was intermittently using family and medical leave, maybe, I need physical therapy under my doctor's order, something like that, then you could pay me on the days, if I come in and work for 3 hours, but then I have to leave because I'm using family medical leave, you could pay me for a partial day. Other than that, the rule has been, if I come in, if I'm an exempt employee and I work for an hour and then go home sick, you have to pay me for the full day. So that's may be an issue. Second is, a question I've gotten is, okay, well, that's not going to help me fiscally, right? So if I need to reduce an exempt employee, but I don't even have 3 or 4 full days, what I need for coverage is I need them to work 5 half days or 4 half days. Or, well, if I have to pay them for the full day, that's not going to work. So how about this? What if I reclassify that exempt employee as non-exempt, and I'll pay them an hourly rate, and I know I'll have to pay them overtime if they work more than 40 hours in the work week? Could I do that? You may be able to. On the flip side, somebody could make an argument that, oh, you just converted me to non-exempt to, quote, circumvent the purpose and intent of the Fair Labor Standards Act. And the Department of Labor talks about that. So that's kind of a toss-up right now, both of those. I am in the resources, I think it's the last slide or next to last slide, where I've listed a bunch of resources and links for you. Right now, the Department of Labor is inviting public comment, and we are able to submit as many questions as you want on this. And so I have submitted both of these questions to the Department of Labor. I'm sure they're working frantically and furiously because they need to get these regulations out. So hopefully, I think the more questions we can ask the Department of Labor or suggestions of, would you do this? Hopefully that will help them shape the regulations to meet employees' needs and employers' demands, and we all have both needs and demands, so stay tuned on that one. Now, question furlough. So a lot of people asking, what's the difference between a furlough and a layoff? My answer is, you define it. Here's what I find common practice in the market. Usually, I find a furlough is when you are keeping an employee on your payroll roster, but you are reducing their hours, or you might not have any hours until further notice. So employees starting tomorrow, you're furloughed, you're still my employee, you're still on my payroll roster, but I don't have as many hours for you, or I don't have any hours for you until I can figure out if I do. Being laid off terminates the employment relationship. Sorry, as of tomorrow, I need to lay you off. It might be a temporary layoff. I might recall you, but starting tomorrow, you're no longer my employee. You're off the payroll records. You're fired. Sounds horrible, but the employment relationship is terminated. And if I'm able to bring you back, then what I'll have to do is rehire you. So in this scenario, we have a furlough requiring exempt employee to work 4 rather than 5 days a week. Can we, as I mentioned before, prorate that exempt employee's salary? Well, that seems permissible. It may be. The Department of Labor has noted, and this is an old note, so it's been around for a while, and they said a fixed reduction in salary effective during a period when a company operates a shortened work week due to economic conditions would be a bona fide reduction not designed to circumvent the salary basis payment. So there's a ray of hope here. Again, I've submitted this question to the Department of Labor just for confirmation. For example, they mention here due to economic conditions. I have no doubt in my mind that is clearly what we're facing. But again, just making sure, well, if we do that, I don't want an employee to be able to successfully allege we did that in retaliation because they asked for leave under the new law. And what is that new law? Well, here we go. So I'm going to guess almost everybody's heard more than you probably want to, but not as much as we need to here, about House Resolution 6201, passed by Congress, enacted by President Trump, the Family First Corona Virus Response Act, FFCRA for short. And so there are a lot of provisions in it. We're going to focus on two and mention a third. So Division C is this Extended Family and Medical Leave Act. So who's covered? Employers with fewer than 500 employees. This is I believe, can be a huge impact for employers with fewer than 50 because you've not had to administer family and medical leave before. So this could be new, and we're going to talk about a possible exemption. Now, I'm getting questions from employers that have close, not quite 500, or maybe they think maybe we're over 500, we're not sure. I would urge you, look at the definition of joint and integrated employers. Again, there's a link. You can click on that link and scroll down to question 2, and it will help you. For example, maybe you have your business, but there's also maybe a family member has an affiliated business. You're completely, separate corporate entities, different EIN numbers, but maybe we might share policies and handbooks, or you have completely separate companies. It's a vendor that you use that provides, maybe they, like a staffing agency, they provide you with temporary workers, or so in either of those situations, those two, what you might think are completely separate entities, could be joint employers. They also talk about temporary employees. So we're doing a 10,000-foot flyby here, not going to get in the weeds, but click on that link. If you have questions about this joint or integrated employer, scroll down to question 2, and that'll give you a lot more information and hopefully help you make that determination. So that's the covered employer. A covered employee, so which of your employees are going to be eligible for this new family and medical leave? Any employee that's worked for you for at least 30 days immediately prior to their first day of covered leave. And we're going to talk about what's the covered leave in a moment. This includes a temp, sorry, typo there, it should be a temp you brought on as a regular employee. This is another question I have that I've sent to the Department of Labor. They talk about a temp, but they do not clarify. Are you talking about a direct hire temp, that is a temporary employee that we hired as our employee, but on a temporary basis and then made a regular employee? Or do they also include or intend to include staffing agency temporary employees? That is, workers who come to us through a temp agency, but as far as we think we might be concerned, they're not our employee. So I've asked for clarification on that. So pending, so what does the law do for the smaller employers, those of you with fewer than 50 employees? The law says that the Department of Labor may issue regulations that exempt smaller employers for undue hardship, that kind of thing. So stay tuned, that's on the horizon. Those regulations need to come out that tell us, are all employers with fewer than 50 employees exempt? Are there conditions that need to be met? What's this hardship condition going to look like, etc.? So I don't have any answers on that, and I have no insider information from the Department of Labor. So what is the qualifying reason? It's just one reason in addition to all that already exists under the regular, if you will, Family Medical Leave Act. So if an employee is unable to work or telework, and we'll talk about that in a second, due to a need for leave to care for the son or daughter under 18 years of age of that employee, if the child's school or place of care has been closed or the child care providers of such son or daughter is unavailable due to a public health emergency. So if your employee says, I can't work and I can't work from home because my child under the age of 18, the school's been closed, the child care providers not able to take care of my child, I have to stay home and take care of them. So we have a couple of questions here. What does it mean, unable to work or telework? Whose determination is that? If we, the employer, have provided the employee with the technology for them to work from home, but the employee says, well, I can't because I have to take care of my child. Does that mean they're unable to telework? Or does it mean that once we've given them the technology, they can do it, they've chosen not to do it? Don't have the answer to that. Hoping, again, that will be clarified in the Department of Labor regulations. I will say, just an FYI, child care providers is defined in the law as someone who receives compensation for services on a regular basis. So if an employee says, well, my mom-in-law or my father-in-law or my grandmother or any, family member has been taking care, they've always taken care of my kids, but gosh, now they're staying home, so I lost my child care. Unless your employee was regularly paying for those services, that would not qualify. Now, let's go to the soft side of this. I would suggest, perhaps, give folks as much flexibility as possible. I've been saying, I hope we will treat our employees at least as well in bad times as we do in good. 98% of the stories I'm hearing, I am so proud and honored to work with so many companies that are, they're scrounging to take care of their folks. Advance paid leave, give them flexibility. Some employers have told me they've bought laptops for people. They're just doing so much to help everybody out. The employers that are asking questions like, should I fire my employees today so they won't be eligible for any benefits as of April the 1st, word's probably going to get out. And, trying to get those employees to come back to you when this is all over might be a little bit more difficult. Having said that, it is important that we know what these definitions are. So what else is a part of this Emergency Family and Medical Leave Act? The first 10 days, so if an employee says to you, oh, I need to be out for this qualifying reason, then the first 10 days of that leave may be unpaid at the employee's discretion. So you cannot say, oh, you can't use paid leave, or you have to, and I think some employers may want to do this, oh, you have to use paid leave because I have to reduce my accounts payable liability. So I need you to use up the bank of leave that you have. Not these first 10 days. It's at the employee's discretion. Then after they've used the 10 days of family and medical leave, then the employee has to be paid at 2/3 of their regular rate of pay and hours that they're normally scheduled to work. But that 2/3 doesn't have to exceed $200 a day or $10,000 total. So that raises a whole lot more questions. For example, my employees don't really have, normally scheduled out. Their schedules vary. In that case, the law says, do a 6-month look back and just look, at the average hours worked over the last 6 months. Well, what if it's a new employee? I just hired them last month or 2 months ago or 4 months ago. Or what if they've been on unpaid leave of absence? If the employee did not work over such period, then you use, and I think this is interesting, the reasonable expectation of the employee at the time of hire of the average number of hours per day that they would work. So it's not the reasonable expectation of the employer. It's what did your newly hired person think when they were hired that they were going to be scheduled to work? Easy answer. Hopefully you had that in an offer letter. Congratulations, we're, offering you a full-time position, regularly scheduled to work 40 hours a week, or part-time position, regularly scheduled to work 20 hours per week. Anyway, just so that's a little amorphous there. Kind of stay tuned to that. Whoops. Oh, I'm sorry. Didn't mean to skip that. Now, under the family and medical leave, for those of you that are already covered employers, you have the obligation to reinstate the employee who goes out on family and medical leave to the job the employee had when the family medical leave began. Under the law, job restoration, so that obligation might not apply if you employ fewer than 25 employees and if you meet 4 conditions. And I'm not, again, going to drill down too far into what those are. If you want to see what those are, just click on this link, the House Resolution 6201, and then go to Division C, which is the family medical leave, and you can find those provisions in there. So we're going to leave the family and medical leave portion. We will cover the sick leave portion, but going in alphabetical order, quick next touch would be OSHA. So we have 2 issues to consider under OSHA, the good old general duty clause, and in your industry, I know you guys are going to be much more well-versed in this than I bet. We are required to furnish each worker an employment and a place of employment which is free from recognized hazards that are causing or likely to cause death or serious physical harm. So I haven't met any employer that's saying, oh, come on in, we don't care, you know, contaminate the workplace. I think if anything, employers might be erring on the other side of caution. What I'm not hearing a lot about, and I think we want to keep in mind, is record-keeping requirements. So employers with 11 or more employees are covered under OSHA's record-keeping requirements if you are not an otherwise exempt industry. And so that would mean that we need to record all our recordable injuries and illnesses. So what is that? Again, I've given you the link here. You can click on that when you download the PDF slide. And when you go to this link, on the right-hand side of the page, there's a blue box. And you can just scroll down. You'll see the list of factors that determine whether a COVID-related illness might be or might not be, when it would be a reportable illness under OSHA. So hopefully that'll help you out a little bit. Now, back to the new Families First Coronavirus FFCRA. That's a lot easier, right? So let's talk about the sick leave provisions now, which are under Division E of the law. Once again, who's a covered employer? Exact same definition as under the family and medical leave provision. Note, I don't think I highlighted this in the previous slide. Don't ask me to explain it. I cannot explain it. I even wonder if it's a typo, but I don't think so. So this law was scheduled to go into effect 15 days after enactment, or 15 days from enactment. The president signed it, enacted it on March the 18th. I looked at my calendar, I've counted time and time again, and I think almost everybody thought this was going into effect on April the 2nd. My understanding is sometime yesterday morning, might have been the night before, all of a sudden the Department of Labor's website talks about an April 1st effective date. So I can't explain it, but I would just stick with that for now. Be ready to implement all this stuff on or by April the 1st. And so same definition. If you have fewer than 500 employees, you're a covered employer. Who's a covered employee that's eligible for this sick leave? There's no 30-day waiting period. This is any and every employee. What's an employee? Pretty straightforward. Their law says use the same definition as the Fair Labor Standards Act. And so every employee is going to be eligible for this sick leave. What is it? Up to 2 weeks or not more than 80 hours. So if an employee's out, and we're going to see the 6 reasons that would be covered for this sick leave, need to provide an employee up to 80 hours. So that would be for a full-time employee. Your part-time employees, it would be a prorated portion of that 80 hours. And so it's going to be the employee's regular rate of pay times the average number of hours that they worked for an average of a 2-week period. Now, popular question. Oh, well, that's no big deal. We already offer 4 weeks of sick leave or 3 weeks of sick leave or 2 weeks because we have one of those state sick leave laws. Sorry, this is in addition to any and all sick leave that you already offer. You probably already heard that. If you didn't, don't panic right now because we're going to talk about the tax credit at the very end. and how this law hopefully is going to help you immediately offset these costs, or in some cases almost immediately. So have to provide the sick leave. When and why do we have to provide the sick leave? Well, for any of the following reasons, and there's six reasons. So I'm not going to read each of these. You have them in the handouts, but you can see the first two there, and then reasons 3 through 6. I'm going to put them in the following categories. Reasons 1 through 3 are basically related to the employee's own illness or quarantine, or they're being assessed for the illness. So reasons 1 through 3 are all about the employee and COVID-19. Reasons 4 through 6 are more about the employee taking care of somebody else because their school closed, because that person is sick, or I love number 6, it's sort of a catch-all, and the employee is experiencing any other substantially similar condition. This is absolutely a moving target. So again, first 3 reasons really related more to the employee and this COVID-19 illness. Reasons 4 through 6 related to employees' issues caring for somebody else. Now, I will tell you, I sort of wish they hadn't called this sick leave, because I think that's misleading. The employee doesn't have, look at reason number 5. The employee doesn't have to be sick. The child doesn't have to be sick. The child's just staying home because the school's closed, or the child care provider's closed or not available, unavailable, and the employee needs to stay home and be with their child. So sick leave's a little misleading, but we'll just say reasons 1 through 3 or 4 through 6. So note, as of yesterday, the Department of Labor did publish the poster. You are required to, now the law says you have to post the notice, this poster, conspicuously in your workplace, so whatever location where you have, I'm sure you do have, all those other labor posters posted, you need to post this one as well. I suspect, I don't know, that the Department of Labor regulations may provide some either obligations or options, kind of hope they're options, for employers to give the notice. Because let's face it, a lot of our workplaces are almost vacant, half vacant. So putting a poster up in the lunchroom, nobody's going to see it because they're not here. So the law does not address any way we provide that poster other than posting it in the workplace. I suspect we'll see other options. That was another request I submitted to the Department of Labor is, would you please let employers use electronic posting mechanisms such as an intranet, if you have an email distribution for your employees, something like that. So we'll see if that came out. But at a minimum, you want to download the poster, and I suspect post that by April the 1st. So how much sick leave do we have to offer? So we know it's for up to 80 hours, again, prorated for our part-time employees at the employee's regular rate of pay, not to exceed $511 a day or $5,110 total for reasons 1, 2, or 3. So it's pretty much 100% of the employee's regular pay up to $511 or $5,110 total for reasons 1, 2, and 3. For reasons 4, 5, and 6, it's 2/3 of the employee's regular rate of pay times the hours they regularly would have worked in an average 2-week period, not to exceed $200 a day or $2,000. The way I keep these straight in my head is, again, reasons 1 through 3 are really about the employee. So when the employee's out because they're sick, they're quarantined, they're being assessed, then we're going to try to give them 100% of their pay, but with these caps on it. So you have a little bit of a shelter there. If it's reasons 4 through 6, it's not about the employee, it's about somebody they're trying to care for. We'll still support them, but you're only going to get 2/3 of the regular pay, again, with the cap set in there. So we're going to leave then the sick leave, and finish our alphabet soup and then go to some of the common questions. Title 7, avoid making assessments based on national origin or race of any individual, an individual with whom your employee associates, or an individual's associated country. For example, employee, okay, a couple of weeks ago, before this, well, let's just say a couple of weeks ago, an employer called me and said, one of our employees was in Italy, they're coming back, and what do we do? You know, we are not sure we want them to come into the workplace. Well, if that person is, Italy is their national origin, that could be, you know, oh, will you let other people who traveled internationally come back to work, but not me? I think that's because of my national origin. Now, of course, our answer would be, oh my word, absolutely not. And then, well, it's just because we heard in the news that Italy, so you may want to follow the guidance, these travel advisories published by the CDC and or the Department of State. Once again, no surprise, these agencies are issuing different guidance and different advisories. As of yesterday when I looked, CDC has a level 3 advisory, Department of State has a level 4 advisory. So what you may want to consider is if you still have any people in your workplace, which you all do, nature of your industry, and someone had another employee was going on a cruise and they were still going to go, which was interesting, but that aside, if you want to tell someone that they cannot come into your workplace because they just traveled, maybe look at, again, you can click on either of those links, they'll take you right to the listing. You may want to do that in consideration of these travel alerts and say it has nothing to do with national origin, country of origin, any of that. We are considering the guidance published by our federal agencies, and that's the list that we're using to say that you can or cannot come back to work. The next bullet, adverse impact analysis. I'm not sure how you're going to find time to do this. Please do talk to your company's legal counsel. You may want to do a pretty quick assessment just to make sure if you're having a layoff, maybe also and a furlough as well. Just see if that's going to adversely impact any particular group. For example, trying to give practical application as we go through this. I was talking to a smaller business this morning. Again, they're trying to reduce the fiscal impact. They're definitely going to have a furlough, trying to figure out who to furlough, and they are looking at their higher paid employees. Their higher paid employees have been with them longer. Their higher paid employees who have been with them longer tend to be, more often than not, older than the employees who are making less money and have less seniority. So could that decision, if they, furlough or lay off the higher paid employees first, could that adversely impact our older employee population more than the younger? Yeah, it could. Does that mean you're not going to do it? No, it doesn't. It just means, just think through that in advance so you know what it looks like before somebody else raises the question and you're like, ruh-roh, didn't think about that. So again, and I would also just put out there for consideration, talk to your company's legal counsel. You may, if you do an analysis, you may want to either have your legal counsel do it or do it under the direction and control of your legal counsel. So the results of that analysis are under attorney-client privilege and have some protection there. We're getting to the end of the alphabet, unemployment insurance benefits. Again, this changed since last night when Congress, and you probably heard, so Congress did finally pass. I'm not even sure if the president has signed it yet. He may have this morning. So the third round of legislation or new law addressing these issues has at least been passed, if not enacted. As of yesterday, even still, a lot of states have relaxed and or expanded their unemployment insurance benefits programs. So again, on that previous slide, if you click on the House Resolution 6201, if you look in the law, go to Division D as in David, and that talks about the unemployment insurance benefits. I gave you a link here. You can also click. This will take you to all 50 state unemployment insurance websites. I would say that you may want to consider giving your employees the state link. So if they're furloughed, if they're laid off, they have, or if they have to take themselves out of the workplace for a COVID-19 related reason, they can apply for those benefits. If an employee asks you, am I going to be eligible for unemployment insurance benefits? And answer may be, I don't know. We don't make that determination. The state will make that determination. And that's just a fact. Worker adjustment, retraining, and notification, also and much better known as the WARN Act. So you might be covered under the WARN Act if you have 100 or more employees and you'll be closing a plant, a facility, or have a, quote, mass layoff. All of those have specific definitions. You may have certain notice requirements. I checked this morning. I have not yet seen, doesn't mean it's not out there, I have not seen that the WARN Act is being waived in this interim period of time. If any of you were impacted by the federal government sequestration a couple of years ago, there was some notice pushed out that WARN Act was maybe not completely waived, but there was definitely some flexibility there. But if you're going to have, a fairly significant furlough or layoff, close a facility, just double check and see if you're going to be covered under the WARN Act. And I think last in our alphabet soup, workers' comp. Just reach out. If you're not self-insured, reach out to your carrier and just ask them, hey, do you have any recommendations for us for avoiding compensable illness, injury? Is there anything that you recommend that we do to facilitate claims, prevent claims? How can we make your life easier? AKA, how can you make our life a little bit easier if and when those claims come in? I think your carrier would probably appreciate that. I also suspect you've probably already heard from them. Quick touch, this is just, oh my goodness, just a couple. There are so many state and local law implications. So I thought I'd just touch on a couple. A number of states and some local jurisdictions have what they call fair scheduling laws. If you're in one of those, you're probably already familiar with it. I won't go into detail about what it is if you're not familiar with it. My question is, and I haven't seen a state that's waiving it yet, but in short, it's, laws that say you have to post the work schedule in advance, and if you change or modify a schedule or a shift, you might owe an employee a portion of the shift that you canceled, changed, modified, etc. That would be a huge hit. Again, we didn't have any notice of a lot of this stuff, and to require employers to pay a portion of the shifts that have been modified, postponed, changed, scheduled, I would hope, again, state and locals are going to waive those laws in the interim, but check in your state or local jurisdiction. If you have liability insurance, again, you might want to talk to that carrier as well. Are we covered? Somebody says, oh, there's some tort claim you subjected, was intentional infliction of harm, aside from OSHA general duty clause. Just, ask them, is there anything that you recommend we do to avoid any claims under our policy? Myriad sick and safe leave laws, state and local. For example, if we tell an employee that they have to use sick and safe leave that's provided under a state or a local sick and safe leave law, and the reason the employee is out is because their child's school is closed, that generally doesn't fall under a covered reason under these state sick leave laws. So just be careful. You don't want to violate a state sick leave law by making an employee use the state sick leave for a non-qualifying reason. And if your head's spinning, just grab onto your desk for a second and center. Lots of moving parts here. And I mentioned the Federal WARN Act. There are at least 19 states that have mini WARN laws. I think I just saw one state may have been, maybe it was New York. Don't quote me on that. Don't quote me on any of this because it's all a moving target. But some states may be waiving that. The other thing, I'm not sure I said this in the beginning besides the legal disclaimer, everything you're listening to live right now or on the recorded version of this program, wait, 12 minutes, it could change. So this is all based on the information, at least I have reviewed as of about 30 minutes before this live webcast. So it really absolutely has the potential to change. So last Friday on the call, these were a couple of the employment-related questions that I heard. One was, can we take employees' temperatures, and if so, how? So I touched on that earlier. How do we reduce employees' hours? I touched on that, and my answer is very carefully and in consultation with your company's legal counsel. Can we require a doctor's note? We touched on that earlier with the CDC and the EEOC's guidance. Number 4, how do we communicate to our workforce if an employee tests positive for COVID-19? I want to share with you a quote. This is from the CDC's website, and it says, if an employee is confirmed to have a COVID-19 infection, employers should inform fellow employees of their possible exposure to COVID-19 in the workplace, but maintain confidentiality as required by the Americans with Disabilities Act. The fellow employee should then self-monitor for symptoms, parentheses, fever, cough, or shortness of breath. So there's the CDC's answer to that question. Other questions I'm getting are a whole lot, just a couple that seem to be a little bit more popular than others. I already touched on the travel restrictions. You may want to, again, click on the CDC, click on the Department of State websites, and consider the countries or the locations in those warnings. Again, a lot of questions about what's the difference between a furlough and a layoff, what are the pros and cons of each. I touched on that a few minutes ago. When and how, whether I furlough somebody, lay somebody off, when I do that, how does that impact an employee's eligibility under the FFCRA? That I do not have a definitive answer. I'm doing some internal speculation about what I think the answer would be. But remember the example I gave before? Well, if I fire or furlough somebody before April 1st, will they be eligible for any benefits on or after April the 1st? I don't have an answer. The Department of Labor will need to answer that question. Seems to me if I'm fired today, I'm not your employee on April 1st, so you would not have an obligation, I would think, to provide any benefit under FFCRA because I'm not your employee on April 1st if you fired me today, if you laid me off. If I'm furloughed, I'm still on your payroll roster, so I might be eligible for some of the benefits on April the 1st. But what if I took myself out of the workforce today? Am I eligible for the benefits on April 1st, or is it only absences that begin on or after April the 1st? So there's a bunch of spins and twists. I do understand, again, I've sent those questions to the Department of Labor. Some of you may have heard they also hosted a Twitter chat. For those of you that are on Twitter, you could get the Twitter feed. It was hashtag E as in Edward, P as in Paul, W as in water, chat, EPW chat. If you're on Twitter, look up that hashtag and you can follow the Twitter feed. Yesterday, I think it was around 1 o'clock or so. I will tell you, I did not find it responsive to any of the questions I think that I've presented here. And you still might want to read the Twitter feed, and it may have useful information for you there. What's on the horizon? I am keeping an eye on the time. We have 8 minutes before our 60-minute conclusion, and then, as Taryn said, we have time for questions if you like. I'm not saying I'm going to have any answers, but we have time for you to ask questions. So what's on the horizon? I mentioned the EEOC is going to host a webcast tomorrow. That is at 2 o'clock, same time as the AICC call. And on the next slide, you'll see I have a link there. So don't worry, you can click on it after. You can click on it at 3 o'clock tomorrow. And my understanding is it will be available at and after 2 tomorrow. What are we waiting on from the Department of Labor? So they published the poster yesterday. We still need a model notice for unemployment insurance eligibility, because the law says under Division D, under the unemployment section, that we have to give employees notice of their unemployment insurance rights and eligibility under the new law. So Department of Labor has to give us a sample notice. At least we don't have to do that from scratch. And the law also directs the Department of Labor to issue guidelines about how are we supposed to calculate the amount of sick time. Remember, it's the regular rate of pay over the last 2 weeks for the sick leave, last 6 months for the family medical leave, lots of questions. Now, this I'm really going to be interested. So we know Department of Labor has said, we, the employers, we're covered under this new law April 1st, not April 2nd. Well, the law also said that the Department of Labor had 15 days to publish those guidelines. So I would hope the Department of Labor is going to give itself that same, however they calculate 15 days, those should be out by April 1st as well. But that's why I have a question mark. I guess it depends on how you count the 15 days. And there's the myriad resources. I told you that I would touch on this issue of the tax credit. So if you're panicking, oh my word, I didn't know about all this paid leave stuff. How in the world can I afford that? Please, I don't practice anywhere in the area of taxes. I know I have my own accountant. I don't know about taxes. What I'm going to do is read to you just a little excerpt, and you'll see the 5th bullet, Department of Treasury. You can click on that link. It'll take you to the website. And so here's how, and forgive me if you're already familiar with this, but I know I'm getting a lot of questions. Here's what it says in part. When employers pay their employees, they're required to withhold from their employees' paychecks federal income taxes and the employee share of Social Security and Medicare taxes. You know that. You're already doing it. And you're required to deposit those federal taxes along with their share of Social Security and Medicare taxes with the IRS and file quarterly payroll taxes. Well, when you are providing eligible, if you're a covered employer and you're providing qualifying sick or the family and medical leave, the paid portion, you will be able to retain an amount of the payroll tax equal to the amount of qualifying sick and child care leave that you pay rather than deposit it with the IRS. So the payroll tax that's available that you can keep includes withheld federal income taxes. So you're still going to deduct the taxes from the employee's pay, but you don't have to turn it over. So what do you get to keep? The withheld federal income tax, the employee share of Social Security and Medicare taxes, and the employer share of Social Security and Medicare taxes. And they give a real quick example. If an eligible employer paid $5,000 in sick leave, and is otherwise required to deposit $8,000 in payroll taxes, including the taxes it withheld from all of its employees, you, the employer, could use up to $5,000 of the $8,000 of taxes that you were going to send to the IRS and use that to make the sick leave payments. And then the employer would only be required under the law to deposit the remaining $3,000 on your next regular deposit date. And they give another example after that, but I just wanted to share that briefly. So we have 3 extra minutes. That ends the portion that I had planned. So now I'm going to be quiet, and Taryn, I guess I'm off, you're on, and I will follow your lead from here.
Thank you, Christine, and thank you everyone for showing up today and being on the call. Before we get started, we do have some questions. We are going to read them and answer them. So if you want to stay on and hear it, you're welcome to stay on. If you want to listen to the recording and get them then, you can do it as well. Before we get started, I'm going to call on Mike D'Angelo, president of AICC, who had a few things he wanted to say.
Thank you, Taryn. Just to echo what Taryn said, I know a lot of people are going to stay on for the questions. Just wanted to thank all of you for attending this webinar, and thank you, of course, to Christine for sharing her expertise with us. She has been a valued partner of AICC for a long time, and she's always quite reliable and very open with her information, and we appreciate it very much. Two quick housekeeping things. AICC will post the FFCRA poster that Christine referred to tomorrow morning at the www.aiccbox.org/COVID website. That's at the AICC site. And Christine had mentioned that if the information changes, which she's pretty sure it will, and typical of the government, I'm sure it will too, AICC will try to schedule Christine for another webinar so that we can handle any updates of that sort. So with that, thank you again. Taryn, I'll turn it back over to you.
Thank you, Mike. Okay, Christine, first question of the day, and this came via email. The FFCRA would necessitate some documentation to validate the excuse provided by the employee. Our concern is if it takes it beyond the pay period to get this information. Does the FFCRA require payment of the time off in the same pay period, or will it allow it to be paid once the documentation is provided?
Okay, well, as I said a few minutes ago, I'm likely to not have answers to a lot of the questions, and let me at least try to share some information that might be helpful until we get the answers. I don't know the answer to that. Here are some thoughts. First off, there is some guidance about the documentation, and the first recommendation, CDC, everybody's pretty much saying, who said anything, give your employees as much flexibility as possible. And because the doctor's offices are inundated. So if we're talking about, for example, our policy says you have to provide a doctor's note, if you're out more than 2 or 3 consecutive days. Think about some creative alternatives to the traditional doctor's note. Can the doctor's office send an email? If the employee is quarantined by a public health agency, can they forward that email or notice to you? Can that, is there something a little bit different? A lot of doctors' offices are doing telehealth now. So maybe there's something that'll make you feel better or more comfortable, I should say, about validating the need for leave. And with all that's going on, maybe you just want to waive that. As far as whether you can defer it, most of the guidance seems to be saying you can still follow your regular notice requirements, which are generally, if you know you're going to be absent in advance, let us know. But a lot of this time, I wake up, I feel like dirt, and oops, I have a fever, so I'm going to call you. If you made your requirement for documentation stricter than you usually do, it could then be turned around and say, oh, you're retaliating against me in violation of the law because I'm seeking my benefits under the law. So, for example, I do see a lot of policies that say if you're out for 2 or 3 days, you have to provide a doctor's note. I'm not sure I've ever seen a policy, and good for you if you got into this much detail, that says if you're out for 2 or 3 days, you have to provide a doctor's note or we will not pay you your sick leave until you provide that. So if that wasn't in your policy or practice already and now you implement it, that's where I'm like, could be looked at not in a positive light, either from an employee relations or a legal standpoint. So little thought there.
Okay, next question. Do you know anyone who has developed any Adobe fill-in forms to be used for submitting the various excuses for the FFCRA? It would seem that most of us would use a similar form.
Wouldn't that be lovely? So here's my hope. When the Department of Labor comes out with either the UI unemployment insurance poster and or the final regulations. I'm hoping, I was hoping they would do it yesterday. So you know the Department of Labor has already published all the family and medical leave notices that are required. I'm hoping, and so the answer is no, I don't know. 2, I'm hoping the Department of Labor is going to publish an updated notice of eligibility rights as well as the designation notice that will include this extra reason for family and medical leave. So stay tuned.
Thank you. Next question. I have a company with 30 people and have never been held to FMLA because of that. Are you saying the FFCRA changes the 50 employee floor to all companies under 500 EEs with exemptions available for under 50 people?
I'm saying tentatively yes. So the law said, so we have law and regulations. The law, House Resolution 6201, says the Department of Labor may exempt employers that have fewer than 50 employees. And it talks about a hardship. And so that's pretty amorphous. So the potential is there for you to still be exempted, period, end of statement. So the potential is there for you to be exempted if you can demonstrate this law would impose a hardship, and we don't know what either or any variation thereof might be until the DOL, and that's then the law said, okay, Department of Labor, you have to publish regulations about this. So that's the best I can give you right now.
Okay, next question. If no one at our company contracts COVID-19, do they ever get to use the additional time, or is it only allocated to having time off for the virus?
It's so the sick leave portion is only allocated to any of those 6 reasons. So it could be nobody's sick but my members, so it could be a child care reason. I think that was reason number 5. And then it could fall under the amorphous number 6, which is any condition similar to, etc. I'm going to guess that's kind of what you meant in your question. So no, it's only available for a qualifying reason under the FFCRA.
Okay. Is the FFCRA points 4 through 6 overlap to the FFCRA Division C emergency family medical leave?
I'm going to say no, and let me flip those pages here. So the 4 through the 6, bear with me one second here. Here's the FML. So the reason the employee's out for the family and medical leave is, again, basically to take care of their child whose school, daycare, etc. is closed. Then we go over to the sick leave, those reasons. So could they overlap? Yes, there's similarity in them. The difference is which of your employees is eligible. So the family and medical leave, that one reason for the family and medical leave, employee has to have worked for you for at least 30 days immediately prior to the first day of leave. On the sick leave side, even if it's a similar, I have to stay home and be with my child, I get the sick leave day 1. So I think that's the distinction between the 2.
Okay, next question. Does this not cover anyone before 4/1?
Does this not cover anyone before? So let me rephrase the question a couple of ways and see if I can try to answer that. And I think it's kind of what I might have mentioned before. So it covers an employee's with you today. Today's before April 1st. The law goes into effect April 1st. And so, yeah, any employees who are on your payroll April 1st and thereafter, they're going to be covered. I guess I'm not sure what the question is.
Okay. Next question. I have an employee that wants to stay home to take care of a high-risk spouse that has no symptoms. Would employee be eligible for this emergency FLMA?
For the FMLA piece, I think the answer to that is no. That's not a qualifying reason. On the sick leave side, I believe, I suspect the answer would also be no, unless, that person was quarantined. And I'll tell you, I have gotten this question a fair amount. In fact, I'm glad you asked, because this is another question I sent, but I sent it to the EEOC. And so let me create a quick little fact pattern. Employee wants to stay home with a spouse because the spouse has an immune deficiency condition. And so they're, if they get COVID-19, they're at higher risk for complications. And again, that's the distinction between just because I'm immunodeficient or older or whatever it is, I'm not hearing from CDC or other that I'm at greater risk of getting it, but I am likely at greater risk once I contract it of having complications. Having said that, again, I've heard this question a couple times. Somebody wants to stay home to be with a family member who's asymptomatic. I talk to your company's legal counsel, wait for the DOL regulations, listen to the EEOC's webcast tomorrow. It's pre-recorded, so we won't be able to ask questions. I think that is not one of the qualifying reasons. I get it. I understand it. But what are you going to do? Stay home and like watch them until they cough? Or, you know, I'm just not sure what you can do in the interim. So in short, I think that is not a qualifying reason.
Okay. Is it correct that we can't reduce salaried employees' pay below the new minimum salary law, regardless if they're working from home or not?
Yes, I believe that's correct. So the question is, and this was even before COVID-19. So the rule has always been the guaranteed minimum salary for an exempt employee, which today is $684 a week. To keep that person properly classified as exempt, they have to, their guaranteed minimum salary has to be at least $684 a week. So if you reduce their schedule to 2 or 3 days and the equivalent, the prorated of what was their regular salary, if the prorated portion takes them below $684, they're not going to qualify for exempt status unless, again, that's one of the questions I pushed out to the Department of Labor, unless they, which I don't expect, but wouldn't that be helpful, I guess, unless they make an exception to that rule during this period, like through December 31st or something. But right now, that's correct.
Okay. What is the definition of an order as it applies to EFFCRA?
What is the definition of an order?
Yes.
So I'm going to think that's talking about the public health order. So an order to quarantine or to self-isolate.
Well, there's another question right underneath it from the same person that says, is a self-quarantine to prevent COVID-19 covered under the Act? So it might be related.
Oh, there we go. And the answer to that is, I believe, yes. So one is reason 2, the employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. So yeah, and that I just say, you know, can you quick PDF, does anybody use fax anymore? I don't know, PDF, or send me just, you know, a copy of the advice from the healthcare provider to self-quarantine. Mm-hmm.
Okay. Would you be willing to discuss the exemptions that employers with less than 50 employees may be able to use to exempt themselves from FFCRA? I believe you mentioned there may be some. If not, are we subject to all aspects of FMLA law until this is lifted? Thank you.
You're welcome, and I'm sorry to say I am not able to discuss that only because that's what we're waiting on from the Department of Labor. So
Okay.
Stay tuned.
Okay. If a doctor recommends an employee stay home from work to prevent possible contamination of a family member with a compromised immune system, does their work absence qualify as a COVID-19 related absence?
Say that again. If a doctor
recommends an employee stay home from work to prevent possible contamination of a family member with a compromised immune system, does their work absence qualify as a COVID-19 related absence?
Oh, okay. I get it. So this is similar to the other question. Employee wants to stay home. I get it. Maybe that's what they meant. So I want to stay home so I'm not coming into the workplace to be exposed. So I think it could be, because go back to reason number 2. So the employee's been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. Doesn't say the employee's, infection of COVID-19, but so that's a concern related to COVID-19. The doctor said you should stay home so you don't contaminate your household member. So I think it could be, yeah.
Okay, there's a question coming up that I don't understand, but there's 2 questions this person asked together, so I'm going to read them both and then we can see if it makes sense. How will the employees for the deduction be? And then the next question is, do we have to declare the named employees who are on leave somehow for the tax credit?
I don't know the answer to the second one, because it's kind of, what do you report to the IRS when you submit taxes? So I don't know, but I don't see anything in the law that references that. But I can see why you'd ask the question, because if we're audited, how are we going to prove we didn't, oh yeah, we had 30 people that were out. So I was talking to one employer this morning, and they're coming up, I think this was a great idea, a separate payroll code. So when they pay either the sick leave or the family medical leave wages, they're going to code it, I don't know what, just say COVID-19 or whatever. So if they need to audit or do a look back or anything, they'll know exactly what leave was paid related to FFCRA. And I'm sorry, Taryn, what was the first? I answered the second question. What was the first again?
It says, how will the employees for the deductions be? And that's all it says. I don't,
Sounds like maybe just the word was missing or something.
Yeah. So if you're on the phone, please post again and we'll read it at the end. Are state shelters and are state are state shelter in place orders considered satisfying qualifying reason number 1 for paid leave?
The employee is subject to federal, state, or local quarantine or isolation order related to COVID-19. I would think yes.
Okay.
Department of Labor, I know that's been a popular question as well. A lot of questions are exactly that question. Hopefully Department of Labor will address that in the guidance. Basically what's a local quarantine or an isolation order? Does it include these? So I would anticipate yes, but I don't know until the regs come out.
Okay. This question says it's a follow-up. Without hardship, do I now have to follow FMLA?
Without hardship, so I'm going to guess you're an employer with fewer than 50 employees.
Yes, he just confirmed that. Yes.
Beautiful. Okay. So today I don't have the answer. None of us will have the answer to that until, I'm so sorry, I just keep saying until the regulations come out, but that's what we're waiting on. So the law uses the word may. So you may be exempt. And then the law said, okay, Department of Labor, you have to publish regulations. So we just don't know until those come out.
Okay, and I have one more question then and a couple of comments. We have employees now staying home taking care of children. Would it cover them now?
I believe it would not, because the law doesn't go into effect, which means the benefits don't go into effect until April 1st.
Okay. So thank you, Christine. And just finally, one of the attendees asks, can you send something that we can click the links? They are not accessible on this platform. The PDF is listed under the handouts on this platform. You can download the PDF to your computer. It does have the links included in it. Additionally, Chelsea will be sending out an email with the recording as well as the PDF, which also includes the links, and you can access it there. So I hope that helps you. If there's any other question, one more. The biggest exemption available for employers of less than 50 would be the ability to run the business without them. Yes or no? Well, that's for you, Christine.
Yeah, say that again. The biggest benefit. Say it again. I'm sorry.
The biggest exemption available for employers of less than 50 would be the ability to run the business without them. Yes or no? And I'm gonna unmute Mike so he can talk to you about that.
That was Mike. I was trying to type fast because you were wrapping up. Sorry about that.
That's okay.
My understanding of the biggest exemption available for businesses with less than 50 employees is if you lose a certain employee and it changes the essential nature of your business in that you can't operate without that employee, that would exempt you.
I would love, Mike, if you can send me that information, I appreciate it. I'm not aware. I keep saying I've been waiting for the Department of Labor regulations to tell us what those hardship exemptions would be. So if you have a source that's cited them already, please share with me. I learn as much from y'all as vice versa. So
I'll try and track it down. I think it was from the National Association of Manufacturers and some interpretive statements. So sure, I'll see if I can find it and I'll send it to you.
Oh, thank you so much. I appreciate it.
Okay, Christine, two more, and then we're going to close this up. What if we don't want the exemption? Meaning, I want to get the credit back from the from the feds. That's my real question.
Oh, okay. Well, here I go again. I don't know until so the question, I guess, is when the regulations come out, will they be mandatory or not? And I think the answer to your question would be, if you don't want the hardship exemption, you wouldn't have to take it. It would be, my understanding is, it will be an option for employers with fewer than 50 employees.
Thank you.
So
and
you
then,
don't have to. Yeah, you're good. Go ahead.
Will a follow-up email or link to include questions and answers be available? Michelle, the questions and answers are going to be recorded on this webinar, so it will be included in the recording. I do believe I get a copy of the chat log with questions, but the answers are on the recording. So I hope that answers your question. Well, everyone, thank you so much for the time that you gave us today. Just as a recap, we will be posting the FFCRA poster at the Industry Update website tomorrow, so you can download the poster there. If the information does change, AICC will work with Christine to see if we can schedule another webinar as more information comes available. And all of you will be receiving a copy of the recording as well as the PDF, which includes all the links that you can use and listen to at home. And then finally, tomorrow we have our COVID-19 forum at 2 p.m. Eastern Standard Time. You all should have received the link for that call, and if not, please contact us or we'd be happy to send it to you. I also believe it's on the COVID-19 on our website under the COVID-19 information. Any other questions? Feel free to email me at any time, and I look forward to hearing from you all again soon. Talk to you later. Bye-bye. Thank you so much, Christine.
Everybody. Thank you. Be well.
Be well. You too. How do I close this out?